definition of a startup. You might have been following the government's action plan that was announced just over a week ago. A startup is an entity that is incorporated or registered in India, which has under 5 years, which has been in existence for under 5 years. It is an entity that could be a company, a partnership, or an LLP. That means a sole proprietorship cannot be a startup. It should not have been formed by splitting up or reconstructing a business that is already in existence. Its annual turnover should have been less than 25 crores in the preceding financial year. And it has to work towards one of 4 things: innovation, development, deployment, or commercialization of a new product or service that is driven by information technology or intellectual property. Now, this is exactly where a lot of the doubts and questions have arisen, and it has been said that this is a sort of unhappy compromise of a definition, because it does not explain what innovation is or what innovation can be. For example, if there is a business that leases furniture to young professionals who move between cities and who do not want to buy a sofa, a fridge, and a television and so on for themselves, is it solving a problem? Yes, it's solving a problem that currently exists. Is it in the business of information technology or IP? No, it is not. And therefore, it's unclear whether a startup such as this would be categorized within the government's definition of a startup. It's therefore likely that the government will come forward and clarify the definition of a startup and what innovation is in the near future. In my opinion, it is important that businesses that are marginally reliant on IT or IP should be given an equal opportunity for making use of the government startup benefits. The government has done its best to sort of make a compromise between over-regulating startups and under-regulating startups. I thought it was a refreshing change that the Prime Minister suggested that they be told what not to do, which is a great change from our previous license Raj. The only sort of regulation as far as a startup is concerned is that every startup needs to get a certificate from the Inter-Ministerial Board, which is to be set up under the DIPP, which is the Department for Industrial Policy and Promotion. It is important that this board does not only consist of government officials, but also consists of entrepreneurs and those who have had experience in startups. In my opinion, the process of obtaining the certification should be time-bound, and a physical presentation by the startup to the board should be done away with. Other than in cases when it has been rejected, in which case a startup should be given an opportunity to come before the board and present why it should be categorized as a startup. There is also going to be a mobile app on which a startup can be incorporated, which is another welcome and refreshing change. If we can move on to structuring a startup, most of you will be familiar with the basic structures of a company, a partnership, and an LLP. Once again, I'd like to remind you that it cannot be a sole proprietorship. Just to very quickly take you through, a private company, it needs 2 shareholders and 2 directors and a minimum paid-up capital of 1 lakh. A public company needs 7 shareholders, 3 directors, and a minimum paid-up capital of rupees 5 lakhs. If one opts for a company as a startup, then it's likely that it would start as a private company and not as a public company, because it requires a lower minimum share capital. The advantage of incorporating an entity as an LLP is that it allows flexibility within its internal functioning, because the internal functioning will basically be the agreement that the partners have between each other. An LLP consists of ordinary partners and designated partners. The designated partners are responsible for the regulatory and legal compliance of an LLP. It needs 2 designated partners who will need to apply for something called the DPIN, which is the Designated Partner Identification Program. Sorry, there's a Designated Partner Identification Number, not program. which is akin to directors, the DIN. And they also need to obtain a digital signature certificate. And once approved by the regulator, the LLP agreement, so the agreement between the partners, must be filed within 30 days of incorporation. Structuring the business is important, but it is also important to advise the startup or start one on your own, knowing fully well how one might exit from it. Let's face it, there are a lot of startups that will fail, but in my opinion, no entrepreneur fails. The word exit has been used by the government in their recent action plan in a very different context from the word exit that an entrepreneur would understand. So the government uses the word exit as a winding up of the company and not sort of selling out, which is what is understood by entrepreneurs. The government has come out with various policies as far as a fast-forwarded exit mechanism is concerned. And they have said that a startup can be wound up within 90 days of initiating its exit procedure. However, the caveat is that this would tend to happen only if that startup has a simple debt structure. Now, if you have a terribly complicated debt structure with an English company having invested through a Mauritian subsidiary into an Indian company and debentures and ESOPs and so on, it's going to be very hard to wind up a company like that within 90 days. But the government has done its best for simple structures. This is a welcome initiative because it makes little sense for a company going through bankruptcy to pay more money in a long drawn winding up process. To give you an example, one of my recent cases, which was the one that was mentioned, which was before the Privy Council, was an appeal from a Cayman Islands company, which was a hedge fund, where two of the partners who had good relations until the real estate market was doing well, and then after the Lehman Brothers breakdown had a fallout with each other. One of whom said they wanted to wind up the company, the other wanted to buy the first out. Now, the winding up has been ongoing for about 3.5 years, and $2 million have been spent in the winding up of the company. At the start of the winding up, the company had assets worth about 20 million because it also had goodwill. Now it has assets of less than 1 million. So neither the shareholders are going to benefit and nor is the liquidator going to get its full $2 million of fees. Moving on to compliance, the government has announced that there are going to be no inspections as far as labor laws are concerned for the first 3 years. And they have also said that startups can self-certify through a mobile app, which is again a welcome initiative, for 9 laws between labor and environment. Now all of this is welcome, but you need to know that self-certification does not mean non-compliance. Startups still have to comply with all of the labor laws, all of the environmental regulations, and that can be burdensome because India has about 200 labor laws. The most important ones that startups will need to comply with are the payment of PPF, the payment of gratuity, leave, contract labor, and the most recent act which deals with sexual harassment in the workplace of female employees. Startups also need to be aware of sector-specific compliance. For example, if your startup is in the finance industry, it's likely that you will need to comply with SEBI regulations. Moving on to the next topic is public procurement. The government has announced that startups bidding for public contracts will be faced with relaxed norms as far as experience and turnover is concerned. There will be no relaxation as far as quality or technical parameters are concerned. It might be said also that this is only for the manufacturing sector. I've already touched a little bit upon employment and labor laws. Other important features within labor laws that a startup often comes across is ESOPs. These are the employee stock options. It is a good way for startups to compensate their employees because they are cash strapped and don't have sufficient amount to pay them full salaries, and therefore employee stock options are a way of compensating their employees as well as retaining their employees for the longer run. Now, ESOPs need to be executed through a plan document as well as a grant letter. The plan document must set out the scope of the ESOP. It is a very good idea for ESOPs to get board approval, and if you are advising an employee, it's essential that you get them to obtain the board approval from the company. There is a minimum 1 year between granting an ESOP and vesting of the ESOP. And lock-in periods can kick in after vesting. Lock-in periods also tend to kick in after a company goes public. To give you an example to make all of this simple, I'm currently advising an employee of a company who before its listing on the New York Stock Exchange had got ESOPs. He was told verbally that these ESOPs had been passed through the board. This was not the case. The company went public and lock-in restrictions have kicked in. So while the ESOPs is vested in him, he was unable to sell these ESOPs for a period of a further 18 months. And by which time the price of the share fell and he was left with a bank balance that was poorer than if he would have been immediately able to sell his shares upon them vesting. Other employee and labor rules and regulations that one needs to comply with the main one is the letter of employment, which would be the grounds for termination, compensation, structure, the employee's duties and responsibilities, dispute resolution, confidentiality, and so on. One can also include non-compete and non-solicitation clauses. Generally speaking, non-compete clauses are not enforceable in India after termination of the employee's duration with the company or with the LLP. Non-solicit clauses, on the other hand, are enforceable. So, if an employee were to set up a rival company in the same sector as its previous employer soon after his or her contract terminated, even if the contract said that this was not allowed, the courts would uphold it. However, if he solicited with him and took with him an entire team of people or customers and the customer database and so on, then the courts would come down heavily on it. Lastly, an employee policy handbook should also be circulated periodically. This should cover employee benefits, leave policies, compensation policies, emails and the use of computers, drugs, smoking and alcohol policies, the code of conduct and general behavior of employees in that entity, sexual harassment policies, complaint procedures, travel and expense policies, and so on. It's quite important that these are circulated periodically, a couple of times a year at least, to ensure that no employee can turn around and say that they were not familiar with this process, especially if they have entered the company after the email was last circulated. Tax, there's been a lot of buzz because the government has announced a 3-year exemption from income tax. Now, this exemption is only applicable to entities incorporated between the 1st of April this year to March 2019. It is unclear whether these 3 years from incorporation, whether it is going to be 3 years from incorporation or 3 years from the date that the startup starts to make profits. Capital gains tax is also exempt. There are various caveats to this. If an investor or a promoter sells their own companies and sells their own properties and invests proceeds of that property into the startup, the capital gain that they would have made on the sale of the property is exempt from capital gains tax. Moving on, let's say the company actually did well and the promoter exited from that company. At the time of exit, if the promoter invests what he has received at the time into a fund of funds set up by the government, then that is also exempt from capital gains tax. However, it's unclear when he exits the fund of funds if that would be exempt from capital gains tax or not. There are also problems that I foresee might crop up for those who want to sell properties and who will invest in companies and sell immediately to avoid paying taxes. The government is also likely to bridge the gap between the long-term capital gains tax on listed companies and unlisted companies. So for example, if one were to sell their shares on the Bombay Stock Exchange or the National Stock Exchange, if one has held those shares for a period of 1 year, it's exempt from capital gains tax. However, if you've invested in a private company and you've held that for 20 years, even that is not exempt from capital gains tax. And the government is likely to bridge the gap between these two. Investments from some jurisdictions, such as Mauritius, is not taxed, whereas other jurisdictions, such as the US, are taxed. The government is also likely to address this and other. The most important thing, however, is to know that a startup cannot take benefit of any taxation exemptions unless it has obtained its certification from the interministerial government, interministerial board that I have previously spoken about. In addition to this, the basic laws that one continues to need to comply with if you are a manufacturing unit and manufacturing products are excise and VAT. If you are a service company, then you will need to pay service tax. All of this, of course, is going to be replaced by GST as and when the GST bill goes to Parliament. Moving on to intellectual property law. A lot of startups at the moment seem to be technology startups, and therefore there will be codes, designs, programs, brands, and so on. It would be very prudent to have all of this IP protected. Some of the major forms of IP that can be protected, as you know, are patents, trademarks, and copyrights. We'll speak about patents in a little bit of detail because the government has announced various relaxations in the application of patents. So a patent, most importantly, can be filed either by the inventor or by an assignee. And therefore it's important that when a company engages a person to develop a patent, they enter into an invention assignment agreement with that employee to ensure that all of the IP that will be developed by this employee will be assigned to the company, will be disclosed to the company, and that there's going to be no dispute about who owns the title, but who has the assignment of the title. The general process of application for patents is that a patent, when applied for, will be published in the Patents Journal, and objections will be invited. Upon removal of the objections, the patent can either be granted or refused by the Patent Office. India grants patents on a first to apply basis, and therefore, if there is an idea that can be patented, it's important that the inventor or the assignee apply as soon as possible. The government has said that the patent fees will be cut by 80%. It's unclear at the moment whether this 80% is going to be a rebate or just a slash of the patent prices to 20%. Of course, this doesn't mean that the lawyers won't have to be paid. The lawyers who file your patent registrations will have to be paid. Patent pendencies are to be brought down to US levels in 18 months. The government has hired 1,000 new patent examiners and have outsourced some of this to the IITs. Trademark pendency is also to be brought down to 0 within 12 months. Lastly, as far as intellectual property and protecting it is concerned, one must think about entering into a non-disclosure agreement. And this could be with anybody, it could be with the startup's contractors, employees, sometimes even customers. Important clauses in a non-disclosure agreement are the definition of what is confidential and what it is that comes within the purview of that agreement, the term for keeping that information confidential, and the terms governing its use. For example, the disclosure can only be made on a need-to-know basis, and a person receiving this disclosure should also comply with the same terms that the non-disclosure agreement had between the startup and the contractor, client, vendor, and